This is Dick Duff again, and today I'll be talking with Barry Engel. Now, you all should know that I'm reading The King of Torts, which is a John Grisham novel, and I know Barry as the king of asset protection planning. He is literally around the world and in Denver at the same time, and it's indeed a privilege to have Barry here. Today we're going to emphasize being proactive in protecting one's assets just in case a lawsuit occurs, and what can be done in that regard. Barry, first of all, tell me a little bit about your law firm, Engel & Ryman.
Be happy to, Dick, and thank you for the invitation to come in and speak with you here. We are an 8-attorney firm here in Denver. Our practice is an international practice. The focus of 5.5 of the attorneys is on this area of asset protection planning. The other portion of the firm is more of a traditional transactional practice. The firm itself has been around about 20 years. I myself have been in practice about 25 years. Right about this point in time, we hope we're almost getting it just about right.
Well, you know, we met maybe 10 or 15 years ago, and at that time, we viewed, or at least I did, our society in the U.S. as a litigious society. Here we are 10 or 15 years later, and I'm going to ask you what's changed.
Well, I think the statement you make is still true. Things certainly do seem to ebb and flow. At times it seems to be a little worse out there, and at times it seems to be a little bit better. My perspective is that it just may be when it seems better, we're kind of used to it. In other words, the litigation problem will continue, it'll go up, and then it might level off and it might feel okay for a little while and maybe back to normal, but it keeps trending up. So I think today, when you look at where we were 10 or 15 years ago, the environment, as I've heard it termed, the culture of litigation is certainly as prevalent, if not more prevalent, than it was in the past.
Well, as financial advisors and insurance agents, we're kind of a funny bunch. Some of us sell securities. Others wouldn't touch them with a 10-foot pole. We're more concerned about promises and safety and guarantees. So the people listening to this are all across the map in terms of the people for whom they work, what they do, and the products that they have. But they're dealing with annuities and insurance primarily. Now, who is the most likely plaintiff that you can imagine who might come after one of these planners?
Well, that's a good question, Dick. And, I haven't researched it or done any independent studies, or I don't have any statistics. And, anyway, studies show, I think it's 73% of all statistics are just made up on the spot. Maybe it's 78. I think I read another study. Anyhow, I have read in the press recently, in the popular press, a lot about older people, senior citizens, and how they are viewed as being prey for some of the bad financial planners out there. And I would say that in terms of a plaintiff's group, perhaps that seems to be a large group, or over the course of time, attorneys will become more in tune to the fact that if they're looking for potential plaintiffs, this might be a group to tap.
Would you include with those folks their potential beneficiaries?
Well, I certainly would. I think you're describing, say, somebody coming along perhaps and alleging that you should have sold my dad more insurance, or you put mom into the wrong investment products and my inheritance isn't as large as it should have been, or something like that. Is that your concern? Is that what you've seen?
Partly. And the other one is that surely dad or granddad would have included me as a beneficiary, and I'm not. Mm-hmm. When you think about that, that can be very interesting because granddad or dad or grandma or mom are not around.
Well, that's right. I mean, of course, there are times when mistakes are made. And there is probably a balance that should, in theory, be there, or at least we would think it would be nice to have that balance between when people are being sued where it's a just case, but then the other side of that balance is all the cases where the one case of precedent turns into something that's made into the mountain from a molehill, and there are a lot of cases based on the one that really have no business being brought.
I want to get quickly into the prevention aspect of all of this, which I identified at the beginning. But before I do, in the ordinary day routines that we get into as financial planners, insurance agents, what can I do to reduce my exposure to litigation, or for that matter, a consumer complaint that might occur? What are some of the business practices you would suggest? Secondly, what do you think about E&O coverage? or malpractice coverage or
shouldn't
the
ask
like.
too many questions because I'll forget them.
You'll forget them, okay. Have a senior. You're not a senior yet, Barry.
Not yet.
So, well, let's just take good business practices. Prevention is important to all of us, and what do you suggest there that would be helpful to be able to trot out in the event that someone sues you?
Sure. And that question alone can be the subject of a full-day seminar, so I won't go on, because then you might forget the next question, too.
I'm more likely to.
But certainly good business practices, I would say, include keeping a proper corporate entity, doing business through the right entity, one that, of course, properly traps liability, keeping the entity up and running in proper form so that if minutes are required, there's some sort of compliance, then, of course, that's taken care of so that the threat isn't a meaningful threat, i.e. the threat of piercing the veil of the company, which is oftentimes brought on the fact that the individual didn't treat the company separate and apart from himself or herself, of course. And that being the case, why should a court recognize some separateness? So we want to make sure that compliance is in place. Compliance can, of course, also refer to compliance with the government, not just corporate minutes and the like. So any form of reporting, tax-wise, otherwise. Today, people involved, of course, in the financial industry, that naturally implies being involved with money. Then there are a lot of rules out there, anywhere from anti-money laundering legislation to just reporting on what you have to in terms of keeping your company current. So good compliance is very important. Watching what you sign. Not only signing properly, i.e. if you're signing for the corporation, signing in your corporate capacity, but watching what you sign. It used to be that people would come in almost laughing about the $10 million guarantee that they signed, thinking that anything over the first million doesn't matter anyway. I might as well sign a $100 million guarantee. What the heck difference does it make? Well, the trouble is sometimes those are continuing guarantees, and years later they do have a lot more than they initially had, and a lot more is at risk if something were to go south. All of a sudden, it does make a difference over that $1 million figure. So as estates grow, people have to be in tune to the new exposures they have, not the least of which might be some old guarantee that's hanging out there. But as a general principle, if you don't have to guarantee or you don't have to tie everything up when you guarantee, don't. Keep in mind, a bank perhaps will start, or a lender will start with whatever you got we'd like. And there's nothing wrong with negotiating that down or trying to negotiate out of it. Then, of course, there's personal planning. By personal planning, I mean aside from corporate planning or entity planning, holding assets in proper form so that if something does happen, not everything is exposed. There's a number of ways to title property, and how you hold property or how I hold property certainly impacts somebody's rights against that property if there's a claim one day.
Not to interrupt you, but wouldn't you say it's also important to know who you're doing business with? For example, there's a tendency to combine forces in real-life financial planning situations where 2 or 3 of us join together to form either a loose-knit relationship or one that's more formal, like you're saying, a corporation
Absolutely.
or the like.
Sure.
But isn't it possible that if you and I, as financial planners, banded together to do some activity, maybe put on a series of seminars or the like, and then we disband later on, that what we did might come back to haunt us just a little bit? So isn't the way we work and relate to each other important? Would you reduce it to writing as to what we intend to accomplish and how we're going to do it? Or would you say it's better to just have it loose-knit?
Well, I think the practical side of it is very few people really will go to the effort to reduce something like that to writing. I mean, I think an agreement is always good to have. Sometimes it's better to have it so extensive that you cover every conceivable situation, and sometimes the less said, the better. I guess it depends which side of the lawsuit you're on in terms of analyzing that one. Of course, doing business with the right people is important. Aside from what you suggest, there's also the idea of being careful with the cases you take, not to take every case that comes in the door.